And Mr. Simon?
Yes, Your Honor.
Okay, I just want to say this to you.
Yes, Your Honor.
So when Miss Weidling is there swearing in an interpreter and you need something stapled, you didn't think I saw that? So, no, the only thing I'm going to say is she was not offended.
We open on laughter, but don't mistake this for a light docket. Judge Simpson's courtroom always carries rhythm, and even moments like the stapler incident serve a purpose. Notice how the judge keeps it humorous yet controlled. He acknowledges the comedic value, but also reinforces boundaries. Bring your own staples next time. That's subtle authority. In a courtroom, even minor gestures matter. Who interrupts, who reacts, who thanks whom. It all shapes perception. But here's the real hook. Today's session moves from humor to high-stakes legal consequences in minutes. We're about to see a fatal crash case dismissed because of permanent brain injury, a high-BAC plea involving a .175 blood alcohol level, a controlled substance case with sentencing uncertainty, a disorderly conduct charge tied to public disturbance, and finally, one of the most tense moments of the day, a bond dispute involving a girlfriend, shared children, and alleged shoving captured on body cam. What looks like a routine docket becomes a layered study in discretion, constitutional safeguards, and judicial restraint. The question throughout this entire session: when does the law prioritize procedure over emotion, and when does it tighten control for safety? Let's break it down.
I was not offended, but I will just say, next time, bring your own staples.
Thank you, Your Honor.
Yeah, all right, you're welcome.
I thought there was pretty decent comedic value. That was the only thing.
You were so happy when she did the little thing, and then you just took off. I asked her, did he even say thank you? She said no.
I didn't want to.
That's okay. No, I didn't want to interrupt. Okay, all right, never mind. I am so done with you. Court calls the case. People versus William Katkey.
People.
Good afternoon, Your Honor. Tyler Velo, P number 75702 on behalf of William Katkey, standing to my right.
Your name, sir?
William Katkey.
Thank you.
Today's the date and time set for the probable cause conference, Your Honor. A discovery has been exchanged. We'd ask that this be set for an exam.
Okay. So discovery is complete and people have their witnesses available on the 25th.
Checking just now, Your Honor. Just have 1 second. Sir, can we possibly go one more week?
Counsel, have any objection to that?
No, Your Honor. Don't have an objection to that.
Okay. All right. Well, if you did, then let me know. All right. Preliminary examination in person, April 1st, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Zachary Brutder.
Artuso, there's a hearing on behalf of people, Your Honor.
Good afternoon, Your Honor. With on behalf of Zachary Brutder, who's joining us by Zoom.
All right.
I think he's there.
Yes, he's there, and I just need somebody to unmute. If he could state his name, please.
Zach Brutder.
Thank you.
Your Honor, the court had been in receipt a few weeks, approximately a month ago, or just slightly less than that, of a report from the Center for Forensic Psychiatry finding the defendant incompetent and not restorable.
Correct.
This is the most legally significant moment early in the session. Incompetent and not restorable isn't casual language. It means the defendant, due to documented brain injuries, cannot understand the nature of the proceedings or assist in his own defense, and medical experts believe that will not change. Under constitutional law, you cannot prosecute someone who is incompetent, period. It doesn't matter how serious the underlying charge is. And here, the underlying facts are devastating. A high-speed crash, a deceased passenger, catastrophic injury. But the justice system is built on process. If a defendant cannot participate meaningfully, the prosecution cannot ethically proceed. The prosecutor even clarifies that there's no reasonable expectation restoration efforts would succeed. Then here's the difficult reality. Dismissal doesn't erase the tragedy. It simply acknowledges that the courtroom cannot function without competency. Would you feel satisfied as a victim's family knowing the case can't move forward? Or does due process outweigh that frustration?
Just as a bit of a backstory, just so I can make an appropriate record, the facts of this case involved an accident where the defendant was traveling at a high rate of speed, car crashed, and the front passenger in that vehicle died. The defendant also suffered a number of brain injuries in that accident, and as a result, led to the report, which the court is in receipt of. Because of the fact that the defendant, the reason for his lack of or his incompetency is a brain injury, there's no reason to believe from the Center for Forensic Psychiatry standpoint or in my review of both that report and the relevant case law that I have any reasonable expectation a petition would do any good as far as this case in the future. If there's any reason to believe that even over a long period of time, there could be some competency restored, that may be a route that we would go. That is not the case here, nor do I have any reason to believe that the defendant not being under a mental health petition is creating any danger for himself or others. So for those reasons, at this time, the people would be moving to dismiss this case without prejudice, and I'll have a knowledge process filed with the court.
Without prejudice is crucial. That phrase means the case could technically be refiled if circumstances change. But given a non-restorable brain injury, the practical likelihood is minimal. Judge Simpson accepts dismissal swiftly. No objection from defense, no dramatic pause. And that's what stands out. This life-altering moment unfolds quietly. A fatal crash case resolved not through trial or plea, but through medical incapacity. The judge closes with, "Good luck to you, sir." Not theatrical, not emotional, just measured. Justice sometimes ends not with punishment, but with recognition of limitation.
Is there any objection to any of that?
There's not, Your Honor. That's all fair what Mr. Childers represents.
The
The
case
reason.
is dismissed then.
Thank you.
Thank you, Mr. Brutder. Good luck to you, sir.
Thank you.
Say thank you.
Thank you.
Court does call the case people versus John Cahill.
Testimony for the people.
Governor Joe Simon on behalf of Mr. Cahill, who should be present on the Zoom. And Chuck, unmute his device and let him state his name, please.
Wait, we're not on.
There.
How's that?
Terrific. State your name, John.
My name is John Cahill.
All right, thank you.
And we have such today for a probable cause conference. At this time, the people have extended an offer to the defendant to plead to the currently charged count 2 in exchange for a dismissal of count 1. I understand that he's going to accept that offer and proceed with the plea today.
Is that a correct statement?
It is, Your Honor. Mr. Cahill and I, as you can tell, I can't really meet him in my office, but we did review together the advice of rights form,
All right.
and he permitted us to sign it on his behalf, and he's ready to enter his plea.
All right. Does he have the physical ability to raise his right hand?
I don't know the answer to that question.
All right. All right, Mr. Cahill?
Yes, Your Honor.
All right. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Can you state your name again for the record, please, sir?
John Cahill.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high-BAC. Is that your understanding?
Yes, Your Honor.
All right. That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Now we shift to a high BAC operating charge. The defendant admits to a couple cocktails, followed by an accident and hospital blood draw. The alleged BAC .175. For context, Michigan's legal limit is .08. A .175 reading is more than double. High BAC offenses carry enhanced penalties because lawmakers consider them significantly more dangerous. Notice Judge Simpson's precision. He lists every possible consequence. incarceration, fines, community service, rehabilitation programs, vehicle immobilization, prosecution costs. That's not just formality, it's constitutional necessity. A guilty plea must be knowing and voluntary. The defendant confirms no threats, no promises beyond what's stated on record. That protects the plea from future challenge. Here's the engagement question. If facing 180 days maximum exposure, would you risk trial or take a negotiated plea knowing sentencing still rests with another judge?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You went through an advice of rights form and gave Mr. Simon permission to sign your name to that. Is that correct?
Yes, Your Honor.
All right. Did you have any questions regarding any of those rights?
No, Your Honor, I do not.
All right. And in paragraph 5, those explain your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole, sir?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
October 4th, 2023, at East Michigan Avenue near Moon Road in Pittsfield Township, were you operating a motor vehicle?
Yes, Your Honor.
All right. Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
All right. Do you recall what you had and how much?
A couple cocktails, Your Honor.
Were you stopped by the police or was there an accident?
There was an accident, Your Honor.
Okay. And at the accident, did the police arrive?
Yes, Your Honor.
All right. And were you taken to the hospital, sir?
Yes, Your Honor.
All right. And did you have your blood drawn?
I believe so, Your Honor.
All right.
Yeah, the people would allege a 0.175 blood alcohol content. I don't think that's in dispute.
It's not, we stipulate to that.
All right. Do you have any reason to dispute the blood test results in this case, sir?
No, Your Honor.
All right, very good. Based on that, counsel, has the court complied with the court rule and would it be proper to accept this defendant?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at court.
It's your matter, yes.
Pardon?
It's your matter, yes.
Yeah.
The plea is accepted, but sentencing is deferred. This is where the pre-sentence investigation, PSI, becomes critical. Probation will evaluate criminal history, substance use patterns, employment status, and overall background. A recommendation will follow. Here's a key legal safeguard. Even though the parties agreed to no upfront jail, Judge Simpson explicitly states he cannot bind the sentencing judge. That preserves judicial independence. Many viewers overlook this nuance. Plea agreements are recommendations, not guarantees, unless specifically structured otherwise. The process moves forward methodically. No theatrics, just procedural momentum.
So a pre-sentence investigation in order is ordered at 14A1 probation. Sentencing will be April 9th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Your Honor, and thank you. Is there a way, would the court permit, if I can work it out with your probation department, if he could report by video? If I could.
Yes, I'm not going to have a problem with that. I thought maybe, but we don't have them up today, that we might have been able to put him into a breakout room right now. But yeah, if that's fine with the court. Whatever way is satisfactory with Ms. Valera. All right. Bond will continue.
Thank you.
All righty. Thank you, Mr. Cahill.
Your Honor.
Thank you.
Yes.
While I admit to aspiratation and control, the staple in question resides in the court's file right now.
Oh, it does?
There's no permanent intention to deprive permanently.
So the staple is back to its rightful home. Good. Court does call the case. People versus Stephanie Serene or Serene.
Right. Thanks.
Serene.
Your Honor, Joe Simon, on behalf of Ms. Ryan, Stephanie, state your name.
Stephanie Serene.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of use of a Schedule I to controlled substance. And that plea, I guess, is being taken under 7411.
That's correct.
This plea involves possession and use of a Schedule I or II substance, a misdemeanor punishable by up to 1 year in jail and a $2,000 fine. Again, Judge Simpson ensures clarity. He is not the sentencing judge. She signs a waiver acknowledging sentencing will occur before Judge Barr. That eliminates confusion later. Then comes the travel request. Florida, April 9th to April 15th. Timing matters because sentencing is scheduled close to those dates. Judge Simpson's visible head shake signals skepticism. He listens, but he's cautious. In court, optics matter. Asking for travel before sentencing always carries risk.
There's also, and upon her successful plea to that charge, count 1 would be dismissed. There's also the agreement between the parties of no upfront jail. However, this is not my case. I cannot buy Judge Barr to that, so the parties should be aware of that.
And I explained that to my client and she signed a sentencing judge waiver.
All right, very good. May I have her sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
State your name.
Stephanie Serene.
All right, ma'am, it is this court's understanding you're going to plead guilty to the charge of use of a Schedule I or II controlled substance. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr
Yes,
in
Your
the
Honor.
1482 District Court.
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of February 23rd, 2023 and March 16, 2023, at the location of 5301 East Huron River Drive, Superior Township, Washtenaw County, State of Michigan, did you have a Schedule I or Schedule II controlled substance in your possession?
Yes.
All right. Did you have any authority to have either one of those in your possession?
No, Your Honor.
All right. And had you used them?
Yes, Your Honor.
All right. Counsel?
I do want to clarify one thing.
Yes.
My client is not on probation or parole to any other court. She's actually technically on probation to Lara, correct?
All right. Have I complied with the court rule and would it be proper to accept?
The people are satisfied.
Yes, Your Honor.
All right.
True.
I will get right to it.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
Before Judge Barr.
April 15, 2025, 10 a.m. before Judge Barr.
Okay. Your Honor, we're going to work on maybe moving that date and ask the court if it would permit a travel request from April 9 to April 15th. My client's parents, who are actually sitting in the car out in the lot, have family travel to Florida and they want their daughter to join them.
I kept shaking my head no, and he kept talking. He just wasn't paying attention. That's two. That and the staple, Simon. What are the dates of travel?
April 9 to April 15.
And you'll be returning on the 15th?
Mhm.
All right. I'll allow that, only subject to one caveat. If for whatever reason, the date does not get moved in 14A2 for sentencing, then you cannot go, or you must come back on the 14th. You have to be at sentencing. Okay?
This is discretionary balance in action. The judge allows travel, but attaches a condition. If sentencing isn't rescheduled, she must return by the 14th. That's controlled flexibility. He protects court authority while acknowledging personal circumstances. Judicial discretion isn't about sympathy, it's about risk assessment, compliance history, stability, likelihood of return. The message is clear. You may travel, but the court schedule comes first.
Thank
Very
you.
good. All right, thank you. Court has stated it's necessary. Court does call the case People versus Zanza.
And on behalf of the people, Your Honor.
Your Honor, Joe Simon, on behalf of Mr. Zhou, state your name, Zihan.
My name is Zihan Zhou.
All right, I have before me a plea form. Indicates that the defendant would be pleading to the charge of disorderly jostling, the 90-day offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The parties agree to no upfront jail. Of course, I cannot bind the court, the sentencing judge to that. I also don't have marked on this. This is a guilty plea.
It will be a guilty plea. I've been informed by another lawyer for the collateral matters that the factual basis is paramount, so it will be a guilty plea. And
Gotcha.
and you know, I maybe should ask Ms. Zenda, the pleas to disorderly, I don't think that people care on the basis of the disorderly, whether it's jostling or another. Is it? Okay,
All right.
thank you.
Okay. I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name.
Zihan Zhou.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of disorderly person. Is that correct?
Yes, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You
Yes,
understand?
Your
that?
Honor.
All right. Now, understanding all of that, do you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today?
Yes, Your Honor.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Are you on probation? Or
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Your Honor, I don't know that the court said it, and I'm sorry if I missed it. The parties agreed to a sentence of no upfront jail, and my client knows that this court can't bind the remand judge to that.
Yeah, I did say that.
I'm so sorry.
That's okay. No, that's fine. Has anybody promised you anything other than this?
No,
Other
Your
than
Honor.
what's been stated? Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right, and also because you believe that you're guilty?
Yes, Your Honor.
Because of what you've indicated, Mr. Simon, you may move on here.
On the November 15, 2024, in the city of Ann Arbor, at the location of Main and East William Street, were you present on a public sidewalk?
Yes, Your Honor.
At that time, were you loud, and did you create a public disturbance in front of an apartment building?
Yes, Your Honor.
This may sound minor compared to earlier cases, but listen carefully to how Judge Simpson establishes the factual basis. Public sidewalk, specific date, City of Ann Arbor, public disturbance. Every element must be confirmed on the record. If even one required element is missing, the plea can be invalidated later. The charge here, disorderly person, jostling, is a 90-day misdemeanor. Not headline grabbing, but still serious enough to affect employment, housing, and reputation. The plea agreement includes no upfront jail. But once again, Judge Simpson reminds everyone he cannot bind the sentencing judge. That's a recurring theme in this courtroom, preserving judicial independence. Notice the efficiency. No drawn-out narrative, no emotional speeches, just clean legal structure. Here's the question: should public disturbances that don't escalate into violence carry stronger penalties, or is structured probation the right balance?
Counsel, with that, as I complied with the court rule, would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor, and thank you.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
April 2nd at 9 a.m. before the hearing.
April 2nd, 2025, 9 a.m. before Judge Perry. Bond. Bless you. Bond will begin.
Thank you, Your Honor.
Here 8 times.
Wait for me right outside, please.
Court calls the case of the people versus Rick Artuso.
Stepped out.
Yeah, we can probably do this without him. No, I'm kidding. They're coming in. Here they come. You're good, sir. Come on up to the.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Arturo. Saying, am I right?
Your name, sir?
Rick Artuso?
Okay.
Sorry, I'm sorry.
Oh, you're fine.
And you're requesting an adjournment?
Yes, Your Honor. I just got the case. I need to speak to my client, and I was Mr. Childers about a possible resolution at this stage, Your Honor.
All right. April 3rd, will that work for you?
That's fine, Your Honor.
All right. Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right. Thank you, sir.
Thank you, Your Honor.
This exchange is short, but important. New counsel has just entered the case and requests time to review discovery and discuss resolution. That's not delay tactics. That's effective assistance of counsel. The Sixth Amendment guarantees the right to competent representation. Rushing forward without preparation risks reversible error. Judge Simpson grants the adjournment quickly. No resistance. These small procedural moments are often overlooked, but they are foundational. A rushed defense can undermine the entire system. Justice requires time, and sometimes the most responsible ruling is simply granting space to prepare.
Be right out. Court calls the case of the people versus Charles Carker.
Ready, Your Honor. And good afternoon again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Charles Carker, who's standing to my right.
Your name, sir?
Charles Carker.
Thank you.
Discovery is complete. We're requesting an examiner.
People have their witnesses available the 25th. Preliminary examination will be set in person, March 25th, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court does call the case of the people versus Christopher Willis.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Edward Lucas on behalf of Christopher Willis. Christopher Willis.
You're requesting an adjournment.
That's correct, Your Honor. I'd like to address the bond conditions at the appropriate time.
All right. Probable cause conference will be adjourned March 27th, 2025, 9 a.m. As to bond.
Regarding bond in this case, there are 2 counts of resisting that are currently charged. And one of the bond conditions, there was an individual that was present during the event that occurred. And one of those individuals, there was a no contact that was put in place, the no go to. The person in question is his girlfriend that he shares children in common. And then since he was arraigned, he's been having to reside at a different location. and have his mother and her mother assist with exchanges of the children just to get the kids back and forth, but they do reside together. They tend to stay together. There was no charge of domestic violence, and certainly the report can speak for itself and the prosecutor can have their opportunity to give a statement, but I'd like the no-go to provisions lifted. I like the no contact lifted.
Now we reach one of the most tense moments of the docket. 2 resisting charges, allegations of erratic behavior at a U-Haul, a shove captured on body cam. The girlfriend, also a potential witness, shares children with the defendant. They live together. Defense argues there was no domestic violence charge and that the no contact order disrupts family life. The prosecution responds that she is a material witness and that the shove, even if uncharged separately, raises concern. Bond conditions are not punishment. They are protective measures to ensure safety and compliance. But they deeply affect daily life. Here's the core conflict. Do you prioritize family unity and convenience, or caution when volatile conduct is alleged?
Response.
Your Honor, just for backstory, the facts of this case involved the defendant was attempting to rent a U-Haul. He was basically got into a argument with the person working at U-Haul over his ability to rent it. They contacted the police because of the way he was behaving. As the police arrived on scene, as they were attempting to make contact with the defendant, he was arguing with someone, a female who may or may not have been his girlfriend. I'm not sure about that. She was basically trying to calm him down. Based on what the police reported, he shoved her away, and that's when the police were like, "We're going to place you under arrest," and then he fought with the police officers. So that's the basis for why that bond condition is made there. That individual is not a victim on this offense. There was no assault and battery or anything charged out of that conduct. That said,
but I mean, she would be a material witness.
She would be a witness, yes. And I think that based on those facts, while they certainly didn't lead to a separate charge, I would ask that that condition remain in effect, at least for the time being.
If I just may add, Your Honor,
Go ahead.
I've been able to review the video. Everything was seen on body cam. That individuals here and present in the court today would be able to address the court if there's any concerns with contact.
Defense emphasizes that everything was captured on body cam and that the girlfriend is present in court, presumably to show there's no fear or safety concern. That's a strategic move. If the alleged victim is standing in court supporting bond modification, it weakens the perception of danger. But prosecutors think differently. Even cooperative witnesses can change positions later, and once bond conditions are lifted, it's harder to reimpose them. Judge Simpson pauses. He weighs the broader implications, not just the immediate optics.
I think what I'm going to do is I think I'm going to leave that condition in place. Maybe at this time. The Washtenaw address is the U-Haul place, is that right?
That's correct.
Because I have 2 places. And so I see what they did. I mean, and I understand what you're saying, that there haven't been charges regarding a domestic. However, and maybe that's because of what was presumed to be her status. But theoretically, I guess, if the allegations of the people are true, there could be at which then these conditions would go into place. And so I'm going to sort of take the broadest sense of things. And so I'm not going to deny your request to change bond. That may change once the examination comes around and you are before Judge Moore or.
The judge takes what he calls the broadest sense approach. Even without a domestic charge, the alleged shove could theoretically support one. That possibility is enough, for now. He denies the request but leaves the door open for reconsideration at examination or before another judge. That's measured restraint. He's not finalizing the issue permanently. He's preserving stability until more facts emerge. Bond remains. No contact remains. And that decision may be the most impactful ruling of the day for this defendant's personal life.
At some point, you can take another look at that. But given what I'm hearing today, I think the bond condition is appropriate given the circumstance. And so bond will continue motion for bond reduction.
Today, we witness the full spectrum of courtroom procedure. A fatal crash case dismissed due to permanent incompetency, justice constrained by constitutional limits. A high-BAC plea moving towards sentencing with structured safeguards. A controlled substance plea balanced with conditional travel permission. A disorderly conduct case resolved with efficiency. And finally, a bond dispute where family dynamics collided with risk assessment. Judge Simpson's courtroom is defined by structure. He reinforces independence of sentencing judges. He protects plea integrity through meticulous advisements. He grants flexibility, but with conditions. And when uncertainty exists, he leans toward caution. No theatrics, no grandstanding, just procedural discipline. The larger takeaway? Justice isn't always dramatic. Sometimes it's quiet, incremental. And bound tightly by rules designed to protect everyone in the process. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.